Okay, good evening, members. So, I would like to extend my humble greetings to you. I'm so excited because we are going to have a brief lecture on the question which say the impact of the Rwandan customary on the what? On the current laws of Rwanda. So, without wasting time, we are going to start by the programs. My name called Emmanuel Wane Nicola. Allow me to first introduce you the guests of honor of the programs of the today, which is going to emphasize on the topic, and then after we're going to ask a lot of questions based on what is going to say. So allow me to introduce the guest of honor, Honorable Patel. You are most welcome.
Ladies and gentlemen, esteemed guests and fellow participants, I'm here as the speaker and representative of the delegate from Supreme Court. I am together with my subordinates from Supreme Court. My names are Odemuka Paterne, where I work there as Vice President of Supreme Court. Today you get here to delve into a profound theme that intertwines the rich tapestry of Rwandan society with the modern legal framework. The impact of Rwandan customary laws on contemporary written laws. In our exploration today, we shall navigate through the intricate web of customs, traditions, and their resonance in the realm of justice, particularly focusing on hearing, inertness, judgment, murder, objection, prayer, predictions, sanction, sentence, witness, and verdict. Today, we are going to get a great understanding of how the ancient Rwandan customary laws and traditions mix with our legal system we apply in Rwanda today. At the heart of any legal system lies with the concept of hearing, the fundamental right to be heard, to present one's case and to have a fair trial. Rwandan customary laws, deeply rooted in the character of the land, have historically upheld this principle through communal gatherings where disputes were resolved through dialogue and consensus. These hearings, often held by under the guidance of the respected elders in the society, provide the platform for all parties to voice their grievances and seek resolution within the community. Another concept we will be looking at it is inheritance. Inheritance, it is another concept of the Rwandan customary law that is a cornerstone of Rwandan society. This embodies the essence of continuity and the familial bonds, the distribution of property and assets in Rwandan society, not only considering the family ties, but even also considering the role and the status of the individuals within the community. At that time, while distributing the properties, they may recruit a lot, considering to their female siblings. But in today's legal framework, in modern framework, the law ensures the equity and gender balance, where in the distribution of the properties, everyone gets equal. Another concept that I'm going to tell you about, it is the judgment. This is the pivotal moment where justice is administered. This reflects the values and norms of a society. In Rwanda, the fusion of customary and written laws has led to the great approach of judgment. Blending traditional wisdom with contemporary legal principles, this seeks to harmonize the collective wisdom of the past into the needs of present. That forges a system that is both rooted in tradition and responsive to justice. Another concept we are going to tell you about, it is the MADRA. MADRA, it isn't a new thing, it isn't a modern crime, it is something that is rooted from ancient ages that you can't know is when. That was the biggest crime that was against the Rwandan societal norms. This underscores the gravity of legal proceedings. Rwandan customary laws traditionally emphasize restitution and reconciliation, seeking not only punishment but also restoration of harmony within the community. While modern statutes prescribe distinct penalties for such offenses, the principles of reconciliation and restoration continue to inform legal proceedings, offering pathways to redemption and healing. And the concept, not one concept, but is a bond of concepts. It is objection, and pleadings. These are procedural mechanisms that accused party use to assert his rights and defense. In ancient Rwanda, when someone was accused, he could stand a trial in Gacaca without an advocate. He could stand he and himself without anyone defending him. But in modern legal framework, there is what you call legal advocates, and you know that. Rwandan customary laws, with the emphasis on community participation and consensus building, have shaped these processes, fostering a culture of dialogue and negotiating. In the modern context, these principles endure, guiding legal practitioners in navigating complex disputes, fostering the amicable resolution. Talk about Rwandan customary laws and forget about sanctions and sentences. The ultimate expressions of legal authority carry profound implications for individuals and society at large. Rwandan customary laws, while prescribing sanctions for various offenses, have historically favored restorative justice over punitive measures. This ethos or theory or deeply rooted in the principle of Ubuntu, the interconnectedness of humanity, seeks not only to punish but also to rehabilitate and reintegrate offenders into the community. Another concept you can forget to talk about, it is witness. Witness, it is the custodian of the truth in legal proceedings. This occupies a central role in the pursuit of justice in Rwanda, where oral traditions have long served as a repository for collective memory. The testimony of witnesses holds immense significance in resolving the disputes in Rwanda as the strongest evidence in the court or in the hearings. Witness was the significant evidence. Customary practices of communal accountability and testimonial corroboration have found a resonance in modern legal frameworks, reinforcing the importance of truth-seeking and justice-serving. Another concept that is very, very, very significant in this theme of today, it is verdict. The verdict is the expression of the revelation of the judgment, the revelation of the decisions from after the Paris Arc pleads. The judges or the mediators must proceed with deliberating the decisions of what is going to be done in the measures or disputes. The verdict in the ancient Rwanda or in Rwandan customary laws, it could be pronounced by those elders that were respected in the society, who were there in the hearing of the dispute of those parties. The verdict was also very binding. So when the losing party told to do something, could do so without hesitating. It was so binding. And don't get confused when I say ancient Rwanda. Ancient Rwanda is the Rwanda that was governed by the king. Okay, don't get confused. Don't think when is ancient Rwanda. In conclusion, the impact of Rwandan customary laws on modern written laws is a testament to the resilience and adaptability of legal systems in responding to the needs of society. Continue to navigate the complexities of justice. Let us draw inspiration from the wisdom of the past while embracing the imperatives of the present. Through dialogue, collaboration, and steadfast commitment to justice, we can forge a legal framework that honors our traditions, upholds our rights, and paves the way for a more just and equitable future. Thanks.
My fellow members, lawyers, as you have heard from the guest of honor, he has been explaining a lot of things. But first, I wanted to say a big thanks to our guest, the Honorable. I would like to say thank you so much for your massive presentation. At this point, we're going to give a question. Okay, before we start our question, I would like us to at least give our clap to our guest of honor, Miss Honorable. So let's put our hands together for the massive presentation. Thank you, thank you. We need to have a systematic way, whereby you have to raise your hand first. We give you a chance. So if anyone has a contribution on the question, that person has to what? Has to give some clarification. First, you have to introduce yourself. After, then you have to proceed with your question. Okay, anyone with question, you have to raise your hand. Any question? Okay, you're most welcome.
Good evening. I'm here by the name of Jose Agia. I want to ask a question. How do Rwandan customary law on modern influence the concept of hearing in legal proceedings? Thank you.
Thank you. My name is Mutani Claudette. I'm going to answer the question that my colleague has asked, that how the customary law influence the hearing on the modern legal proceedings. As Honorable Patel said that healing in customary law involve community involvement and consensus building, which influence the modern legal proceedings by promoting transparency and inclusivity. Thank you.
Thank you so much, my sister, for your answer and for your contribution toward the question. So we are going to move to the second question. So if you have any question.
My name is Mr. President, and my question says that, could you elaborate on how inheritance is governed by Rwandan customary law and its integration into modern legal framework? Thank you.
I have an answer. So my name today I would like to answer my sister about the Rwandan customary law, how it was distributed. So the Rwandan customary law, it was distributed based on family ties and society laws. These principles has been adopted fit modern legal frameworks, ensuring fairness and protection of rights in inheritance matter. Thank you.
From my brother is from Rwanda, so I would like to appreciate him on the question asked. So we are going to give another question. So if you have a question, please have your hand so we can proceed because we don't have time.
I'd like to ask this question, which states that how do Rwandan customary laws contribute to the judgment process, particularly in cases of murder? Thank you.
Okay, thank you. By the name is Nadia Nyeneza, and about the question my fellow asked, as we have heard from the presentation of Honorable Mr. Patel, he said that Rwandan customary laws historically emphasize the institution and reconciliation even in case of murder, while modern statutes prescribe distinct penalties. The principles of reconciliation and restoration continue to inform legal proceedings, offering pathways to healing and redemption. Thanks.
That was a good question from my fellow Congolese, and then answered by my fellow Rwandan also. So we are going to give another question. So we are going just to proceed with the question. So if you are answering, make your answer to be at least short because we are limits of time. So you are welcome. Any question?
Okay, thank you. My name is Vedas Mugan. Okay. My question says that in what ways do Rwandan customer laws serve objective pre and pleading in legal advocacy? Thank you.
Yes.
Okay, thank you. My name is Grace Latosha, and I'm going to respond to the question my fellow asked, which states that in what ways do Rwandan customary laws shape objections, plea and pleadings in legal advocacy? In Rwandan customary laws foster the culture of negotiation and dialogues, which influence how objections, plea and pleadings are presented. This tradition encourages the parties to engage in constructive dialogue and seek amicable resolutions. Thank you.
I'd like to thank those who questioned. They brought a lot of interesting questions, and I would like to thank those who have answered their colleagues. They did in the way that I could even do it myself. And questions actually were said to be too, but I do not allow you to go with that curiosity. It's good that you shared that curiosity with us. So you are going to go without some sort of confusions. Thanks.
I would like to appreciate our guest of honor for his massive presentation on the topics. I would like to say thank you so much. May God continue to bless you. Maybe we'll be able to request you for other topics ahead. So I would like to say that this is not the end of the program. Maybe we'll organize other programs later. So I hope we're going to meet in other programs later. So thank you so much for your contribution, for your question, for your time, for everything. May God bless you. Thank you.